Okay. That was quick. We're gonna go ahead and read the document. So I was gonna wait until court opened and see if someone was gonna pick it up, but a bunch of people had it. So luckily, we have it now and we can read it. Let me just wait for a few people to filter in here. Okay. So we're gonna read the ruling. I'm gonna try to get through it like fairly quickly. Um, I am taking my break from work very early today to do this. So, but like I said, I try to get through this fairly quickly. Um, I know not everybody has time during the week, especially to like read a long document or watch me ramble on about a long document. So I'm going to try to make it a little bit quick. Let's go ahead and pull that up. This is the judge's ruling in Clayton Echard's paternity case. Well, I shouldn't even call it a paternity case. It's like a fake baby case. So yeah. Hold on, let me tweet this link out real quick, guys. Okay. So let's just go ahead and jump right into it. We all know that it's in Clayton Echard's favor. We saw that based on David Gingris's tweet earlier. He is intending to appeal. He made that very clear before the ruling was even out or the trial even happened. So, yeah. Pregnancy? Oh, I remember that video. Yeah. Okay. All right, guys. Let me read this to you. I gotta pull this up on my phone real quick. There we go. Okay. And then I'll skip over some stuff if it's like really obvious and redundant. The court finds at this time this action was commenced at least one of the parties was domiciled in the state of Arizona, blah, blah, blah. Okay, that's not important to us. This is just reviewing the procedural history. We know Laura Owens filed pro se, petition to establish paternity, legal decision making, parenting time, and child support on May. Well, I don't think she filed it on May 20th, 2023. Is that right? Because I'm pretty sure they, you know, okay, we're not going to get into that. This is just talking about all the motions that were filed. Let's see. And we've already been over those extensively, so I won't really do too much of this. It's talking about the, paternity test here that resulted in little or no fetal DNA. How Laura testified in November that she was 100% and 24 weeks pregnant. Okay. Talking more about the paternity testing. Voluminous additional pretrial pleadings were filed by both parties. Those motions were ruled on separately by minute entry, and the rulings are not relevant for purposes of this hearing. Okay. Voluminous. That's a word I don't hear a lot. All right. Petitioner Laura Owens. Petitioner contacted respondent through LinkedIn. So this is just outlining what the petitioner says happened. Petitioner and respondent met on May 17th. She has a podcast, real estate investing company. Between May 18th and 20th, 2023, they viewed some properties in Scottsdale. On the evening of May 20th, Clayton invited Laura over to his home, and she accepted. After Laura arrived, Clayton told her he was high on gummies, and he offered one to her, which she accepted. During the late evening, parties agree that petitioner performed oral sex on respondent to completion twice. Okay, so Laura testified she did not want to have sexual intercourse, but that respondent stuck it in briefly. We all know that's not true because of that awkward email that we've had to hear a million times. But yeah, all right. Just give me 1 second here, guys. All right. We're gonna skip over the real estate stuff because you guys already know all that. Okay. Petitioner testified that after multiple positive pregnancy tests, she told the respondent she was pregnant. Petitioner denies using hormones, someone else's urine, or altering the test at all. Sorry, Discord is distracting me. Okay. Petitioner found respondent's reaction to be hostile and dismissive. She went to Banner. She informed the nurse she thought she was pregnant, and she asked for a test. Test results from Banner was positive for pregnancy. Positive for HCG. Petitioner testified that for more than 6 months prior to May 2023, she was not sexually active with any other men. I thought it was a year. She made that very clear. That's the only reason I know that. I never wanted to know that. I just, we do know that, you know? Okay. On June 19th, petitioner went to respondent's home at his request, took the pregnancy test. Petitioner or Laura is alleging that the test was taken in front of him. So conflicting testimony makes it difficult to ascertain whether the test was taken in front of the respondent, but they both agree the test was positive. In the something to consider email, there we go. The court finds the language to imply respondent was attempting to buy into the idea that rubbing or grinding their genitals together might have led to a pregnancy. The court, however, does not find the email conclusive that respondent believes her to be pregnant with his children, but rather an attempt to consider her assertions. This is just so weird to read in an official document. In the something to consider email, respondent maintains that the lack of sexual intercourse would preclude him from being the father of the fetuses. The email does not deny the pregnancy test was positive. In the email, respondent suggested that the positive test was the result of petitioner's epilepsy medication. Okay, Laura emailed Dr. Zeman from Barrow, a neurologist, not an OBGYN or anything like that. Subject is pregnancy and seizure med. Okay, so she emailed asking about pregnancy and her seizure medications. That does not necessarily mean that she proved or had medical documentation. That there was medical testing from that doctor that proved she was pregnant. That's like, she could just say, like, I'm pregnant. Is it okay to keep taking these medications? So, like, that doesn't really mean anything. Petitioner denies sending respondent an ultrasound video, citing instead that Greg Gillespie hacked into her email and sent the video to respondent. We all know how I feel about that. So, 1 sec, guys. Let me hold that up. There we go. Okay. Here, the judge is saying petitioner testified she sought care at Planned Parenthood in Los Angeles, failed to provide records of any appointment, anonymous or under an alias. She presumably sought records from, or Clayton side presumably looked for records from all Mission Viejo Planned Parenthoods, as that's where she had said she sought care up until the day of trial. Petitioner testified that she had the sonogram at a Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent respondent from tracking down the records. The court was not provided with those records at trial. Petitioner testified that on July 23rd, she experienced bleeding and passed two small fleshy objects, smaller in size than her hand. I'm sure David will be pleased with that wording. She took pictures of the tissue and sought telehealth assistance. Petitioner testified that she texted a miscarriage hotline and sought telehealth assistance. Okay. Telehealth provider told petitioner it was hard to tell if she miscarried and she should monitor the situation and seek further care as needed. Petitioner chose not to seek in-person care that would have confirmed if she had been, still was, or had miscarried. The court finds the hard-to-tell component of the telehealth visit was due to the nature of telehealth and the inability to provide care in the form of an exam, HCG test, blood test, ultrasound, or sonogram. Instead of seeking in-person care, petitioner chose to take another HCG home pregnancy test on July 25th, which was positive. Okay. Petitioner again took an at-home test instead of seeking care on August 1st. I really like the tone of this. Petitioner testified that she made multiple appointments to see Dr. McCool. 3 of the 4 appointments were rescheduled and then canceled when the petitioner tested positive for COVID. Dr. McCool's records indicate 44 pages of records confirming making and canceling appointments. So glad that we had those records. Like, what? That was an interesting choice. She really thought she was going to get away with that. But court was not provided with evidence of the positive COVID test. There we go. But maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. Yeah, no, she was high risk on like so many different levels, so many different variables, and just like, no, I'm not going to go to the ER. It's probably fine. B Stone, hey, what's up? Okay. Court does. Oh, this is fun. In August, they agreed to DNA testing. The court does not find the sexual contact between petitioner and respondent resulted in a pregnancy. So the court does not find that Clayton got Laura pregnant. Definitely didn't get Lauren pregnant. Sorry. The court finds that if Laura was pregnant, it is profoundly unlikely that conception occurred because of rubbing, grinding, or oral sex. During this litigation, if petitioner had maintained consistently an allegation of sexual assault, coupled with a police report or physical exam, the court may find differently. Evidence and testimony, however, do not support this inconsistent contention. So the court is saying outright, Clayton did not get Laura pregnant. It's highly unlikely, and the evidence is just not supporting it. Petitioner admitted to changing an HCG test result to reflect 31,000. I think she meant 131,000 or something, but she put the exhibit number there, so I'm not worried about it. Further testified she altered the document using Adobe, but not Adobe Acrobat. Like, that matters. All right. B. Davis, hey, what's up? Okay. In late September or early October, both parties submitted samples to Rabgen for DNA testing. We all know how that ended. Okay. Petitioner testified that on October 18th, she was aware the alleged pregnancies were not viable and filed the request for pre-decree mediation in the hopes that at mediation she could tell the respondent that the pregnancy was no longer viable. Upon denial of her request, however, she did not file a motion to dismiss or make other arrangements to advise respondent of the development. The court finds this testimony uncredible and a misuse of judicial resources. This is looking really bad for her. Petitioner was not treated by Dr. McCool or Dr. Higley as testified to in her November 2nd hearing on the IAH. Okay. Not treated by those doctors for pregnancy. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable. Damn. She's gonna be so mad reading this. The court further finds that going to Banner for a pregnancy test but not the passage of fetal tissue to be unreasonable and uncredible. A reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of the pregnancies. So, yeah, if she's going to an urgent care to like make sure that she's pregnant, she's not going to not go to see a doctor to see if she miscarried. You know what I mean? So that makes sense. Okay, petitioner testified on November 14th. She sought OBGYN services from MomDoc to determine whether she was still pregnant. At that appointment, petitioner took 2 pregnancy tests that were both negative. Petitioner testifies that she currently weighs 91 pounds but weighed 133 in November. She experienced significant swelling in her abdomen and felt pregnant. I also experienced significant swelling in my abdomen and I feel pregnant, usually after I eat a lot of salt. Court was presented with videos petitioner sent respondent of her abdomen as evidence of pregnancy. Dr. Medshield testified that while she appeared pregnant, that alone was not conclusive of the pregnancy. Okay. Petitioner denies tampering with HCG tests, but does admit to altering and fabricating ultrasounds and sonograms. She further testified that she changed the HCG numbers on 2 of the results. The court finds little, if any, difference in altering the test itself, for which she denies, and altering the results, which she did tamper with by her own admission. This I'm a little worried about. She further testified she changed the HCG numbers on 2 results. I don't remember if she actually admitted to that. Did she? Um, Yellow butterflies. She's in her 30s. I want to say 30, mid 30s, 34 ish. Um, so I don't know if she actually admitted to that, but they did. Her attorney did state publicly on her behalf that she admitted to. Because anything that he puts out there, like for her, that's on her behalf. He's her representative. So it was a public statement that she did, in fact, alter it to a 102,000, and then we know we saw the 131,000 one. So technically, if you are going to go on information she's providing, then yes, she altered it twice. But I don't know if she actually said that in her testimony. I know that she was asked about it in cross. Somebody else correct me if I'm wrong. Okay. During cross, it became profoundly obvious that counsel for the petitioner was attempting to coach her answers. Oh, he's going to be so bad. You're going to get some angry blog post later. That's going to be exciting. Respondent's counsel, identifying the issue, moved between counsel and the petitioner. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. Woof. The court had to remind petitioner twice that counsel would ask a question and she needed to answer it. At this time, petitioner pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner to no avail. At this time, petitioner became emotional and asked for a brief recess, which the court granted. The court finds this interaction between counsel and petitioner diminishes the credibility and veracity of the petitioner's responses during cross-examination. So they're definitely going to argue that. We already saw tweets from him. I don't know if it was this morning or earlier than that. That he was gesturing as a way to object, like he was trying to object. I'm just like, I don't know. I don't think that tracks. But the court will have their own footage from different angles, and they can see better than our stream footage. Because we got some of that on there, but we didn't get all of it. So the judge is spilling all the tea. Yeah. All right. The court finds it is impossible to determine the date of any alleged miscarriage, not because it is impossible, but rather because she failed to seek even a minimal level of care for her high-risk condition. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure respondent would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted. All right, now she's talking about Dr. Medchill. We know Dr. Medchill delivered 30,000 babies. He is the second coming of Christ. That's awesome. No, but talking about his testimony, he reviewed 200 pages of her medical records from Barrow Neurological Institute. He did not review her primary care or historical OBGYN records. That's important. Dr. Medchill testified that none of the medication records he reviewed would cause a false positive home pregnancy test. He testified a false positive HCG test could be the result of epilepsy medication, anxiety medication, clozapine, horse urine, or IVF prescribed injections. Oh my god! Please tell me it wasn't horse urine. That is, yikes. Okay. Dr. Medchill testified that he is 99.9% sure that the petitioner was pregnant based on the HCG tests. He did not change his perspective after petitioner's admissions on the stand that she altered more than one test to reflect higher viable HCG numbers. Oh, man. The court finds Dr. Medchill's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for an HCG, and a prior history of ovarian cancer to diminish his credibility. Oh, the prior history of ovarian cancer. I can't believe that comes back to bite her like years and years later, but thank God, you know? Especially given that records that the petitioner testified existed were not presented to her own expert for review and consideration. Dr. Medchill testified that a blood HCG level of 102 is proof of a non-viable pregnancy. While Dr. Medchill testified that a non-viable pregnancy is still a pregnancy, the court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for the respondent to believe that she was still pregnant with viable fetuses. That is a good point. That is a good point. Louise, what's up? Okay. Dr. Medshall concluded she became pregnant on May 20th, ended with a spontaneous abortion late October, early November, or possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. Shocking. Okay. Dr. Mitchell testified that a woman may expel tissue during a spontaneous abortion. Thank you for explaining that, Dr. Mitchell. Or the pregnancy might remain in her body, ultimately being reabsorbed. Not the reabsorbed thing again. Thank you, Winks. Yes, guys, if you don't mind hitting the like button, I would appreciate that. Okay. Given the petitioner testified under oath at a prior hearing that she was about absolutely 24 weeks pregnant and had seen her doctor presumably in person, the court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. Isn't that something I ever thought I would read in a court document? Oh, man. Okay. Court further finds a miscarriage at this stage of pregnancy would result in emergency medical care and corresponding death certificates of the twins. If what Dr. Mitchell testified to is true, and she miscarried much sooner, negating the need for the death certificates, then petitioner perjured herself at a prior hearing. We're talking about Dr. Deans. Dr. Deans testified there's no data to indicate a conception date. After reviewing the records, Dr. Deans determined HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. Dr. Deans testified that heterophilic autoimmune responses due to exposure to animals could produce a positive HCG test, but the confirmation blood test would be negative. Okay, so we're basically saying so she did have a positive blood test. So are we saying that's not what happened? I guess a prior history of cancer could also produce a positive HCG result. Petitioner has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. Oh my god. I don't believe she had ovarian cancer, but it's so funny that she faked it and it's coming back to bite her. We know Laura Owens faked ovarian cancer. I mean, a forensic expert reviewed Michael Maricini's laptop, which proves that she did. She claims that she never sent it or whatever, but it shows that it came from her number. So, familial HCG syndrome can also produce a false positive HCG test. Dr. Deans testified that syndrome is very rare with only 10 known cases in the world. Horse tranquilizers can create a positive HCG result. Horse urine, horse tranquilizers. Like, do you usually hear these terms in family court? Anybody? Like, Dragon and Winterfell. I'm worried about the fake. I'm worried about the fake cancer being used in the judgment and going to be a basis for appeal. Well, they're her alleged medical records that she created, so it's her problem, in my opinion. But you're right. They will probably try to argue that. Okay. Respondent Clayton Echard. Respondent denies all allegations of sexual intercourse. Respondent confirms both parties were under the influence of marijuana, but denies being high and further denies memory loss because of the marijuana ingestion. Testified that around May 22nd, he realized his behavior was unprofessional and continued to discontinue a sexual relationship with the petitioner. Testified that upon hearing this, the petitioner became very emotional. Clayton testified he told Laura he submitted the offers to the seller. Clayton testified he did not believe Laura was really interested in the properties. Okay, so we're talking about the real estate stuff here, which is like not super pertinent. So I'm not gonna. Respondent testified that petitioner sent him approximately 500 texts using 13 different phone numbers threatening to leak information to the media. Respondent testified petitioner reached out to the son, called his family, co-workers, and prior girlfriends, accusing him of being a deadbeat for not supporting her and the twins. Not supporting her and the twins. That's awesome. I love that she had to go so far as to do the twin thing because it's just like really, really screwed her over in this. Respondent testified that he received the video from petitioner and continued to correspond with her over that email string, which would reasonably prompt petitioner to advise she did not send the video, but she did not advise of that at the time. Okay. Petitioner. Okay, so Laura emailed Clayton, you can't say that you haven't been given a voice when I have told you that I will have an abortion if we try things out for a few weeks and have a good reason for aborting the child. How is that a good reason for aborting the child? I guess he'll want to date me if I abort the child. Like, that's a terrible reason. Like, do your thing, make your choice, whatever. But like that is not it. That is unhealthy. Okay. All right. These words feel menacing because you know I like you and I want to try things out with you. So faking a twin pregnancy is probably going to accomplish that. The email continues. You would be obliging to make the decision to date exclusively before deciding whether or not we have an abortion. Dude, every time I hear that, it never gets less weird. You know? Petitioner encouraged respondent to have sexual intercourse with her, citing she was tight and already pregnant. Okay. Petitioner further emailed respondent that he had control of the outcome of the pregnancy if we date exclusively and care for each other. On June 28th, she said, if you think about it, having sex with me is the safest thing you could do at this point. I'm already pregnant. And if we choose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills. So there's no risk. Dude, like, she's saying, like, if you have sex with me, I'll take abortion pills. Like, that is crazy. That is crazy, dude. Yikes. Okay. Petitioner told respondents twins were a boy and a girl. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. Petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. Petitioner signed a release of records for Dr. Jeffrey Blake Higley, MD at Women's Care. In a letter dated March 18th, the provider advised, we have no record of treatment for the dates of service for your request. Alrighty then. Okay, so here the judge is ruling on the order of protection, or the validity of the petitioner's order of protection. Okay. In this case, so the bulk of Clayton's argument is that Laura fabricated her pregnancy, which could not have resulted from their interactions because they didn't have sex. But he does admit that they engaged in oral sex. Clayton wants to have the order invalidated based on the fabrication, while Laura argues that even if she was never pregnant, the activity between them and Clayton's subsequent harassing online conduct are sufficient to sustain the order regardless. Okay. There's a predicate issue that should be addressed, which goes to the court's authority to reconsider the protective order at all. Put simply, extant appellate authority, namely Vera v. Rogers, and like cases, precludes reconsideration here. Okay. So this is just talking about another case. Mother applied for protective order. It was eventually transferred to the Superior Court after father petitioned to establish legal decision-making authority, parenting time, and child support here. After a contested hearing, the commissioner handling the order of protection affirmed it in its entirety. Father then filed a special action, asking the Court of Appeals to order the family court to amend the order of protection to align it with the temporary parenting time orders it had made in the separate case. The Court of Appeals accepted the special action, finding it raised a purely legal issue of first impression that is of statewide importance, to wit, the interplay between the procedural rules and statutes governing protective orders in family law proceedings. Okay, since I have to kind of rush through this, we're not going to read more about, Vera or whatever. I'll do like a standalone video where I kind of read through this better later, but for now, we're gonna skip that. Okay. Okay. By signing a pleading motion or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief formed after reasonable inquiry. 1. It is not being presented for any improper purposes, such as to harass. Well, let's talk about that. 2. The claims, defenses, and other legal contentions are warranted by existing law. 3. The factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Okay. So again, since we have to kind of get through this quickly, we're not going to read too much about these other cases. Non-paternity. Okay. A man is presumed to be the father of a child if genetic testing affirms at least a 95% probability of paternity. Okay. A man is presumed to be the father based on DNA testing that may only be rebutted by clear and convincing evidence. Based on a lack of confirmed pregnancy and repetitive Ravgen results of little to no fetal DNA, the court cannot establish that petitioner was pregnant. The court cannot establish paternity of a non-confirmed pregnancy, lacking DNA evidence despite testing twice. Here, 2 tests of little to no fetal DNA fall woefully short of the 95% required to meet the almost 95%. Fall woefully short of the 95% required to meet the burden of clear and convincing evidence that respondent was the father of petitioner's alleged pregnancy. Hey, Miss Comings, what's up? Okay. Hold on. Do they actually provide more context up here? I didn't know if they wrote more about Clayton's case or if it was just about these. Hang on. Yeah, guys, don't worry. I'll do a standalone video pre-recorded with a short explanation of all this stuff after. So if we missed anything, don't worry. Attorney's fees and costs. Clayton Echard has requested an award of attorney's fees and costs. An award of attorney's fees and costs is governed by, and then they're talking about the statute here, so I'm gonna skip that. The court finds there is no substantial disparity of financial resources between the parties. Petitioner did not provide an AFI, but testified she and her mother collectively earned $200,000 a year. Respondent filed an AFI on May 15th, citing monthly income of $12,000 and annual income of $144,000. The court further finds that petitioner acted unreasonably in the litigation. Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit. Without an authentic ultrasound, sonogram, physical exam, and in conjunction with a belief she passed tissue in July 2023, the court finds the underlying petition premature at best. At worst, however, fraudulent and made to incite communication, a relationship, or both. Well, that was clear. With the respondent. The court further finds that filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursement for those costs. The court further finds that petitioner repetitively failed to comply with Rule 49, even on order of this court, further compounded by the fact that on the day of trial, she testified that she anonymously sought care at Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged she altered HCG test results, an ultrasound, and a sonogram. How do you Costa? What's up? Hey, Jinjin. Okay. The court further finds that the provisions of ARS 25 to 324 do apply because the petition was not filed in good faith, the petition was not grounded in fact or based on law, the petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds petitioner provided false testimony as to the viability of the pregnancy in all 3 cases addressed in the procedural history. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action she initiated. The court further finds that Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate. It is therefore ordered granting Clayton Echard's request for attorney's fees and costs associated. It is further ordered denying Clayton Echard's request for attorney's fees and costs associated with the OOP and IAH hearings, referencing the analysis above. It is further ordered that Laura Owens shall pay Clayton Echard's reasonable attorney's fees and costs, Not later than July 28th, respondent and counsel for Clayton Echard shall submit all necessary and appropriate documentation to support an application for an award of attorney's fees and costs, including a China doll affidavit and a form of proposed order. By no later than July 29th, Laura Owens shall file any written objection and a form of proposed order. If Clayton Echard's counsel fails to submit the documentation by July 8th, no fees or costs will be awarded. The court shall determine the award and enter judgment upon review of the affidavit, as well as any objections. Additional orders. It is further ordered granting the respondent's petition for non-paternity. That is awesome. So the court has officially said that Clayton was not the father of the fake babies. So it is further ordered, the court having determined that Laura Owens has a pattern of similar, if not identical, behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for a review of Laura Owens' actions pursuant to ARS 13-2702 and ARS 13-2809. Accordingly, the Maricopa County Attorney's Office will be endorsed on this order. So she has been referred for criminal charges. Gorilla BFF. So interesting to hear a sane breakdown of the goings on from the judge. Yeah, definitely. Bad Scooter. I hope Laura comes clean and admits everything now. That'd be great. I don't have a lot of hope that she will do that, but that would be great. All right. The court must decide the amount of attorney's fees and costs to be awarded, but finds there is no just reason to delay making a final order. It is therefore ordered, pursuant to Rule 78B, that this is a final judgment, and it shall be entered by the clerk. The time for appeal begins upon entry of this judgment by the clerk. For more information on appeals, see Rule 8 and other Arizona rules of civil appellate procedure. It is further ordered denying any affirmative relief sought before the date of this order that is not expressly granted above. Done in open court on 6/17. Okay. Well, that did not go well for Laura, but as we know, they'll be appealing, and we'll see how that goes. I tried to read through that as quickly as possible without skipping too much, so hopefully, I got to the good parts. Like I said, I'll do a pre-recorded that's going to be a lot shorter, and it will kind of just summarize that. So, I will talk to you guys later. I got to get back to work. Okay.